tip number 2, Jeff, is the notice of appeal timely? This kind of dovetails in what we were talking about with appealability. We also want to, as the respondent, to pay close attention to whether the appellant has timely appealed from the order. The absolute, no matter what, jurisdictional 60-day time limit for filing a notice of appeal is triggered when one of 2 different documents is filed, either the notice of entry of judgment or a file stamped copy of the judgment served by the clerk or any party. If one of those 2 documents, if neither of those 2 documents has been served, then the default 180-day rule applies in which to take the notice of appeal. If there was a motion for new trial, if there's a post-trial motion, some of those can extend the deadline to file the appeal. So look for motions for new trial, motions to vacate the judgment, or for JNOV, or for a motion for reconsideration. Those may all extend the timeline to take the appeal. But be ready to pounce if the appellant filed an invalid post-trial motion, such as an untimely motion, or a famous one is a motion for reconsideration that is not supported by a declaration. So if a motion for if a motion for reconsideration is just based on new law, but doesn't have a declaration attached to the motion, it's technically invalid. That's a Branner versus UC Regents case, famous case that held that it was.
Or a motion for reconsideration of an order granting an anti-slap, dismissing a case in its entirety. Motions for reconsideration are not allowed for such orders, and therefore it's not valid in terms of extending the time for appeal.
That's a good point. We've talked about that before on the podcast, that after a final order, like an appealable order, such as you mentioned, an anti-slap order, or a final judgment, motions for reconsideration cannot be heard. They are it is beyond the jurisdiction to reconsider a final order.
Right.
The court can set it aside, or vacate it, or grant a new trial under those collateral review statutes, but not under CCP 1008. And also ask, if you're the respondent, whether any of the 5 exceptions apply that were described in the Garg versus Garg decision. There are some cases, rare, but they do happen, where an otherwise untimely appeal may be found to be timely. These 5 rare exceptions are discussed in the Garg decision. The first one is in times of public emergency. Second, when the untimeliness was caused by a superior court clerk wrongly rejecting a timely submitted notice of appeal. Third is where an institutionalized and self-represented litigant's notice of appeal is deemed to be filed on the date it is put in the prison mailbox. That's the prison guard rule. Once you hand it to the prison guard, the notice of appeal is deemed to be filed. For most practitioners, very rare, bordering on vanishing when that exception would apply. Fourth, a rare exception to the untimeliness, to the timeliness rules is in criminal law appeals and juvenile dependency appeals, ineffective assistance of counsel in failing to file the notice of timely appeal can provide grounds for allowing the appeal to proceed. We discussed that before on the podcast in Ray AR, a 2021 case. There may have been a 5th exception. I think it was the exception we talked about in Garg. If that was the one that talked about the electronic filing rules, if you encountered a problem with the electronic filing system that resulted in your notice of appeal being filed untimely, then you can get relief from that untimeliness by immediately filing in the Court of Appeal a motion with a supporting declaration explaining why the electronic filing system broke down. But not every excuse will carry the day, as we found in another recent case. We can talk about that maybe another time. But those are the 5 exceptions to the untimeliness rule. Otherwise, if you see an untimely appeal, be ready to pounce. Those are almost always a good argument to get an appeal dismissed.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.